Hello and welcome to the 30th episode of Business Litigation TV. This is the internet's most passionate show about business litigation. Today I want to talk about practicality. Okay, starting a lawsuit is not always practical. All right, I want to use the image of a bully who basically, does something to you, takes your lunch, pushes you, something like that. And he goes, "What are you going to do about it?" And the person, whether it's you or whoever in this scenario, just basically goes, "Nothing," walks away. Because the bully is 3 times your size, he has 15 people with him, whatever the scenario. Sometimes the law operates like that, and it's unfortunate. I have many clients, okay, and potential clients. A lot of times they've been defamed. Somebody said something really bad and posted it, whatever. And I have to tell them, yeah, you got a valid case. It's going to cost you X amount of dollars to start the case. And they say, I can't afford that. I really can't do that. Okay. So unfortunately your options are you pay the money and you do a case, or you don't and you basically walk away from the scenario. I have another one where a client is being bullied by a homeowners association. She's been trying to get her apartment painted for months. Maybe we're going on a year now. And they're doing everything in their power to not let it happen. And, they keep coming up with ridiculous conditions. And I keep telling my client, listen, you can satisfy the conditions, or you can pay lots of money to start a lawsuit. I'm not saying what they're doing is right, because it's not. But it's up to you which route you want to take. And we're talking about a place that should be painted for $1,000 or $2,000. Do you want to pay $5,000, $10,000 to make the HOA's life hell, to prove that you're in the right? Because there's a lot of clients who come to me and they want to prove that they're in the right. But they can't afford it. And we're not talking about someone who punched them or, who stole $1,000. We're talking, I'm sorry, let me say, I'm not talking about people who are like taking hundreds of thousands from these people or taking their home or anything like that, where it's worth it for an attorney to try it pro bono or on contingency or something along those lines. It's these slights tend to be small enough, but gathered over time. And the question again, it's always a question. It's a cost-benefit analysis, actually. Is it worth it to you? Is it so egregious to you that you're going to spend your hard-earned money and spend your hard-earned time pursuing the case to prove you're right? So, again, the law, as it's written, could be 150% on your side. But if it's too much to actually pursue it, law doesn't mean much in this case, does it? If you've been following me, you'll know I've also done a post called Justice is Blind. Because in civil law, it's not enough to be right. Okay? It's not like, someone's committed a criminal act against you, you call the cops, have them arrested, and the state takes care of the rest. Okay? In this one, and in the United States in general, you pay for your own attorney, you pay your own fees, unless you make it all the way to the end trial, and maybe you get some fees back. Or maybe you have the type of case where you may get your attorney's fees back. That's only if you see it all the way through from start to finish. No settlement, you have to go through the trial, pay for the witnesses and everything. So as a practical matter, despite what the law says, is the case worth it to you? That's something you should always consider before calling an attorney, or even after you've spoken with an attorney. All right, I hope this, while not the most uplifting of posts, kind of shed some light on the difference between law and practicality. All right, and if you have any questions, want to discuss this in the future, you can always email me at Jesse, Jesse, @jdelaw.nyc. All right, guys, as always, thanks for watching, and until next time, take care.